Почки. Почки.
Good morning.
Hi.
Can I help you?
Restaurant?
Right here by the water fountain.
Thank you.
Your left.
Thank you.
Miss Sherry, did you pack your lunch?
Yes, sure did. Sure did, ma'am.
Sure did.
No, her name is Sherry.
Yeah. I'm gonna be broke for a long time.
Hey. Did you get my text or you already knew?
No.
Oh, you already knew. Hey, how are you? Hi.
Is this a good spot right here, John?
Usually they go back over there to speak.
It says up here. Where did you set up for yours?
All I had was a body cam last time.
Go, but really across the state, practice a variety of areas, but a lot of my practice is in local government law. I am a independent hearing officer, special magistrate for the county, which means I'm an independent hearing officer. I'll hear testimony and evidence presented by the county and testimony and evidence presented by the appellant, and make a decision based on the applicability of the county's code. We're here for a trespass appeal, Mr. Gunn.
Yes, sir. We had one case this morning, case number TW 26001. The respondent is Mr. Zachary Cooker, a trespass appeal from the Land O'Lakes Tax Collector's Office.
Okay. And I guess we'll start with the oath thing if whoever's gonna plan on testifying today. If you would please stand and raise your right hand and repeat the oath if you plan on testifying.
Do you swear or affirm that the testimony you are about to give in this hearing is the truth, the whole truth, and nothing but the truth?
Ready to proceed? You all have any questions? Mr. Cooker, is that how it's pronounced?
I'm sorry?
Is it pronounced Cooper?
It's Cooker, yes.
Are you ready to proceed?
I'm ready.
Yes, sir. Before we call the first witness, the county did have a couple preliminary matters. We sent, ahead of the hearing, we sent a motion limiting. We're just asking to exclude any testimony or argument today regarding two different items. Number one, the constitutionality of the tax collector's video recording policy, as well as any testimony or argument regarding any alleged violations of Florida Public Records records laws. And the basis for the motion is not that these aren't serious matters for consideration, but that we're not in an appropriate forum to hear those matters. First, with the constitutionality of the policy, it's the county's understanding that the respondent does disagree with the tax collector's policy. However, this forum is not the proper venue to challenge the policy. As you're aware, the special magistrate's role is a limited role to determine whether the respondent violated the posted policy and whether the trespass warning was issued in accordance with the ordinance, section 66-159 of the county's code. For purposes of this hearing, the policy should be presumed valid, and in fact, I think it's worth noting that it has recently been upheld by the U.S. District Court for the Middle District of Florida. While the respondent may disagree with the policy, it doesn't excuse non-compliance with the policy, and any constitutional challenge to the policy would have to be brought in a court of law. Regarding the public records issue, it's a similar argument. County expects that the respondent would assert that he was attempting to make a verbal public records request and that the tax collector improperly refused that request. However, that issue is not relevant to the matter before the special magistrate. The question in this proceeding is not whether the tax collector complied with public records law, but whether the respondent violated a posted policy and whether the trespass warning was properly issued pursuant to the ordinance again. So even if we assume for the sake of argument that the tax collector did err in refusing to accept a verbal public records request, that wouldn't entitle the respondent to violate the policy. The proper remedy would be to file an action in civil court, and allowing the respondent to use this forum to litigate those matters would exceed the scope of the special magistrate's jurisdiction, and it would exceed the scope of this hearing. So again, we're asking that that those subject matters be considered not relevant and any testimony or argument be excluded.
Anything to say about the motion eliminated? Assume you provided a copy.
So, my response to the motion to eliminate is, I understand the county seeks to exclude constitutional arguments. I'll focus today on ordinance compliance and preserve constitutional issues for judicial review. Within this forum, the determinative questions are whether the county identified a specific rule, obtained a contemporaneous written witness statement, proved disruptive conduct, and tailored its remedy. On this record, it did not. I would also like to just point out that they're using, as part of the evidence or part of the exhibits, they're using Patrick versus McGuire, which is based off of a civil matter, which includes constitutional arguments. So it seems like there's a double standard where they're able to use constitutional argumentation, whereas I'm barred from being able to do so.
Okay. I don't think my understanding of the case that was cited, that they're not arguing that it's a constitutional issue. You're arguing that it's not.
If I can just briefly respond on that, we're not admitting that case as an exhibit in this hearing. I attached the case to the motion. It's even if the policy hadn't been brought in federal court, it's not proper jurisdiction for this hearing officer. I attached the case to show even more so that a court has ruled on this matter, so it would be highly inappropriate for a special magistrate to reweigh it. We don't intend to argue the case, we don't rely on the case, it's not an exhibit in the hearing, but I think it was relevant to the motion that was filed.
Let's see.
County attorney's fighting hard.
As far as the constitutionality argument, I mean, I'll let you make the argument that it's unconstitutional, but I can't rule on that. So there's no real point in it. I mean, he's right. It's not a decision that I can make. It would have to go to an appellate court or a circuit court. If you want to make an objection to the constitutionality, I would reserve some right on record, but I can't determine from my limited scope the constitutionality of the policy, and I would tend to agree that the public records violation or non-violation, the allegation isn't relevant to the trespass itself, so I'd ask that we just not address that today since it's not pertinent to why we're here for this particular trespass appeal.
Am I able to respond to that?
You You can.
So I'm not here to argue whether or not they restricted my rights on submitting a public records request under Chapter 119 of the Florida statutes. The constitutionality is going to be centered more around the what appeared to be the act of recording in a public area, which is the reasoning or the basis of why the DMV, or the tax collector's office, decided to shut down services and prevent me from conducting my business as well as everyone in the building. And that is also the basis for the trespass, is they're saying that the alleged recording is the disruption.
Okay. Well, I guess when we get to that point, we'll hear it then. I'll decide on whether it's relevant or not.
And just before we call first, we're gonna say 3 preliminary exhibits I'd like to introduce into the record. Exhibit A has been marked. It's a copy of the Pasco County's public trespass ordinance. Exhibit B is the appeal form that Mr. Cooper
While he does his
filed in
exhibits,
my office.
he opened up the
Exhibit
case
C is the notice of hearing that went out for today.
by trying really hard
Those exhibits.
not to have
They've been provided to.
constitutionality
Yes, all
arguments brought into the
provided.
case.
I apologize. What are you numbering these individually, or you wanted them as a composite?
Individually, the A, B, and C.
They'll be admitted as counties A, county B, and county C.
The county at this time would call Mr. Benjamin Mason to the voting.
Mr. Mason, you were present when we administered the oath, correct?
Yes, sir.
You took the oath.
Yes, sir.
Thank you.
Good morning, sir. Please state your name for the record.
Benjamin Mason,
And Mr. Mason, where are you employed?
Pasco County Tax Collector,
And what is your position with the Pasco County Tax Collector?
road test examiner, safety agent.
And as a road test examiner and safety agent, what are your general duties and responsibilities?
Mainly to administrate the driving test and also to make sure the office is safe.
Provide limited security services for the office?
Yes, limited, yes.
And could you just briefly describe what does the tax collector's office do?
The tax collector office collects taxes, property taxes and such for the county.
Provide any services to the citizens?
Yes, they also provide driver's license services, registration, title work, that type of thing.
Okay, so are your offices open for members of the public to come in and do business?
Yes,
What are some examples of types of services that a citizen would come in for?
registration renewal, pay the property taxes, title work, renew driver's license.
So you also administer driver's license tests?
We do.
And how long have you been with the tax collector?
5 years,
And how many offices does the tax collector have in Pasco County?
5.
Which office do you work in?
I mainly work at the Land Lakes office.
You sometimes cover at the other offices?
Yes,
Okay. And are you aware as to whether or not the tax collector's office has a policy regarding video recording?
yes I am.
And speaking to the Land Lakes office specifically, is there a sign outside the office that puts visitors on notice of that policy?
Yes,
I'm going to show you what's been marked for identification purposes. Is County's Exhibit D. Do you recognize that?
yes.
What is that?
That's the sign prohibiting recording in the building.
Is it a fair and accurate copy of the photo of the sign that's posted outside your Land Lakes office?
Yes,
Okay, I'd like to admit the photograph of the sign into evidence as Exhibit D, if I may approach.
Yes. Be admitted as counties D.
Is there also a longer, full version of the policy that's been drafted?
yes,
Okay, and is that policy posted inside the Land Lakes tax collector's office?
yes,
Is it also available on the tax collector's website?
yes, What was your question, I'm sorry?
What is it that you're looking at? Is
The video photography and recording policy.
that the same policy that's posted inside the building?
Yes, it is.
County would seek to introduce into evidence as County Exhibit E, if I may approach.
Yes. Be admitted as County Z.
Okay, I want to take you back specifically to September 3rd this year. Were you working that day?
Yes.
Okay, at what time did you become aware that there was an issue with the respondent, Mr. Cooper, in the office?
On my return from lunch,
Okay, so could you describe what you observed when you returned from lunch to the office?
when I walked in, he was recording at the front desk.
Okay, and what makes you say that he was recording?
He had his camera, and when he turned around, I saw it was recording.
Okay, did you observe any customers interacting with him at that time?
Yes.
Okay, and what was their demeanor? What were they saying?
They were upset that they were recording him, causing a disruption.
Who is the lead safety agent at the Land O'Lakes office?
Jerry
And Jerry, what's his last name?
Hunter.
Okay, and was Mr. Hunter present that day?
Yes.
Were you able to make contact with him?
Yes, I did.
Alright, and what did he tell you as far as what had been going on?
He told me that he issued a trespass notice and that there was a disruption of business.
Okay, and when you say he had issued a trespass notice, what do you mean?
The trespass warning as far as stop recording and leave, and he didn't leave, so he trespassed him.
So he had already asked the gentleman to leave?
Yes, I asked Jerry. Jerry said yes, he did.
Okay. Have you also, since this incident, been able to locate the respondent's YouTube channel?
Yes.
Okay, and what's that channel called?
Trolls, Liberty Troll, I believe.
Okay, and have you gone onto that channel and observed the footage from that day?
I did.
And did you confirm from watching the footage that the respondent in fact was actively recording inside your office?
Yes.
Okay, and Mr. Maggard, the county has a copy of the video downloaded for the record. I believe it's over an hour. I don't intend to play the full thing, but just for purposes of this hearing, I would ask to play the first 5 to 10 minutes at this time, and we have it up on the screen.
Yeah, is there a screen that I can see?
Is it not showing up on the computer there? Yeah, on the projector. We've got it up on the big screen. We go to the download version that we have. Yeah, in the file. Well, that's the URL. Remember you downloaded it?
Right out there that everybody in here does not know that.
That is not the law.
Raise your hand if you're afraid of this guy videotaping everybody.
Mason, was that a clip of the video that you observed on YouTube?
Yes,
Okay, and based on your observations that day, as well as comparing with the video, is it fair to say that is a video that was taken by the responding inside your office that day?
yes,
And did you see yourself in that video at all?
yes,
I want to go back on something real quick. You had indicated that, I believe you said Mr. Hunter issued a trespass notice. Just to correct the record, the formal trespass warning comes from the sheriff's office, correct?
yes,
So if somebody's in your office and hypothetically it is disruptive or there's a violation of policy, when you say you issue them a trespass notice, what exactly is that interaction?
that's to say we started the trespass process.
And the respondent, Mr. Cooker, you see him here in the hearing room today, is that the same person that you observed reporting in your office that day?
Yes,
Okay, so with everything that was going on that day, and we saw a little bit in the video, ultimately the office was closed down. Even prior to that, did you have any issues with customers becoming upset? And
while he was in there,
yeah.
yes,
Okay, did that become disruptive to business?
it did,
Okay. Did Mr. Hunter ultimately make the decision to call the sheriff's office?
yes,
Okay, at some point in time, did Mr. Fasano, the elected tax collector, arrive at the scene?
yes,
Did Mr. Fasano make the decision to close down the office?
yes,
And as doing so, did he ask all the citizens that were in the office to step outside and to leave?
yes,
Okay, this disrupted services, disrupted business?
yes,
Okay, did you observe at any time, did Mr. Fasano request that the sheriff's office issue a formal trespass warning to Mr. Cooper from the property?
yes,
And as part of that process, did you observe Mr. Fasano give a written statement to the sheriff's office?
yes.
I have no further questions for this witness.
Sir, do you have any questions for this witness based on what he testified to?
Yes. Mr. Mason,
Yes,
did you personally see me recording as opposed to merely holding a phone?
yes,
You did. Was a written witness statement prepared and provided to the deputy before the warning was issued?
I don't know.
Who decided to stop service in that lobby?
The tax collector. So in the beginning, the office manager.
That service stoppage, not any words or actions of mine, is what interrupted operations, correct?
Your actions,
And that was doing what?
causing the disruptions and violating the recording policy.
How does a camera disrupt business?
Just going off the recording policy or violating the recording policy.
Is the policy to stop operations when you see somebody holding a camera?
If they don't leave and they're disrupt business.
Was I indeed asked to leave?
Yes,
Could it have been that I was asked to stop recording and that law enforcement was being contacted?
I don't know.
Has your office trespassed other patrons for merely holding a phone while conducting business before?
We trespass other people disrupting business.
And the directives around holding a camera are persistent or consistent throughout each incident of somebody holding a camera or a phone.
If they're violating the recording policy, yes.
So you stated that there was a policy posted saying that you cannot or prohibits recording, right? Would you enforce any policy regardless of what it prohibits?
I can't.
What's your objection?
The question was, would you enforce any policy regardless of what it prohibits? And we're not here to discuss other policies, and I think what that's getting at is if a policy was blatantly unconstitutional, would you still enforce it? And that goes to the issue in the motion. We're not here to talk about other policies, we're here to talk about this policy.
You have a comment on that?
I think it's relevant because if we're operating in a vacuum, namely this ordinance that's in place, the point is virtually anything could be within that ordinance, and it could say I can't pray, for example. So another question I was going to ask is, if I was going in there and I wanted to pause and pray, and the ordinance said I couldn't, there's no prayers allowed in the DMV, would they be obligated to give me the same treatment for holding a camera?
Yeah. I'll sustain the objection with relevance. I don't think talking about other hypothetical situations is relevant.
Mr. Mason, are you aware of any law enforcement communicating to me or to others in that DMV that I had a right to be there?
No.
Are you aware of any law enforcement making any statements such as that I know the law?
No.
Who asked me to leave?
Jerry Hunter.
At what time did Jerry ask me to leave?
I was at lunch, like I said, when I came back from lunch, he said that he already asked you to leave. So I don't know what time. It was before I got back from lunch.
So your knowledge of him asking me to leave is coming strictly from Jerry Hunter.
That and your video.
At what part in the video do you have the timestamps?
No.
Did I give you a piece of paper with other questions on it?
You got that Jerry Hunter video? Right here.
Am I able to bring witnesses at some point
Yes.
as well?
So, county's gonna put on their witnesses. As they call their witnesses, you have a chance to cross-examine them based on what they said. Once the county's done, then you're allowed to bring on your witnesses.
Okay, thank
So
you.
if you want to introduce evidence, it would be appropriate to do it during your, what we call case in chief, when you're putting on your witnesses.
Okay.
Ask him if that's the Jerry Hunter he's talking about.
Can I proceed the witness and show him an image of a video of Jerry to confirm if this is indeed Jerry in the video?
I'd ask, if it wasn't sent prior to the hearing, that you show, the county attorney before, but other than that, no, I don't have a problem.
Okay. How would you like me to proceed in showing them this video? It's very short.
Just walk over there and show them what you're gonna show the witness.
Alright, so, could I hand this video, who should I hand this video to show that this is indeed, see if this is Jerry in the video, and then play the
If
video?
you want to ask the witness about it, you can show it just like you did the county attorney.
Right there? No. No, that's not Jerry. It's not there. No. I don't know who that is. Looks like it's probably a customer. Jerry doesn't have a beard too.
Yes.
Mason, would you be able to recognize Jerry's voice if I were to play the audio?
I can give it a try.
Alright, here comes Jerry. Mr. Mason, does that sound like Mr. Jerry Hunter?
Yes, I do remember that. That's from a video from a couple years ago when we first started, the higher ups started to establish the policy. So it's from a few years ago.
Okay, very good. Do you recall what Jerry said then, or listening to the audio now, what he was explaining to the gentleman in the video recording?
No check to relevance and the safety, the different safety officers' interpretation of the policy from several years ago. The policy that was introduced into evidence, I think it said it was updated last year, so we're not even talking about the same policy.
I'll agree. Let's move on to something else.
Could I ask questions regarding like what exactly has changed in the policy since the last 2 years?
Sure.
Mr. Mason, could you recall any specifics as to what exactly in the policy as it relates to recording has changed in the last 2 years?
If you have the old policy, I can review that with the new one and I can give you more specifics.
Fair enough. That's fair enough. At what point should we do that, or would be an appropriate time to do that?
Do you have the old policy with you?
I don't.
Mr. Mount, do you have an idea on that?
I don't have the old policy either, but also I think if you were to ask this witness, he would likely testify that he wasn't involved in the drafting of the policy, and probably is not qualified to speak to that.
Well, I mean, if you don't have the policy, if you don't have the policy with you to ask him about it, I don't know how you want to proceed with doing so.
I'm also not sure why the old policy is relevant, since we're dealing with a policy that was in effect at the time of this incident.
So it's to show that there's inconsistency in this matter of allegedly or recording inside of the DMV, because this particular person who's actually in the courtroom today, who shared this video with me, he was doing the same thing I was doing, and he was told by Jerry Hunter that he can record as long as he's not causing any problems or any issues. And
This is from several years ago that the video
Oh.
from?
what was it, 2 years ago?
Look at the timestamp on the
But
video.
that's the video that we referenced earlier.
Yeah. So this was probably less than 2 years ago. 1 second, let me just verify.
Less than 2 years ago.
Yeah, I mean, I'm just gonna tell you, I don't think it's relevant, because whether that person understood or misinterpreted or properly interpreted the policy, what's relevant today is whether the policy in place was properly applied to the facts of your situation. So whether Mr. Hunter said that or didn't say that, Whether that he was accurate in saying that or not accurate in saying that doesn't really impact what was applied to you.
No further questions for Mr. Mason.
Do you have any follow-up questions?
Just briefly, you were asked some questions during your cross-examination regarding the respondent's conduct and how could the camera disrupt business. So I want to ask you, in addition to just being a violation of your posted policy, in this particular instance, did the respondent's filming have an effect on customers that led to the disruption of business? And if so, if you could please describe that.
Yes, it did. A good description was customers going back and forth. I had to go out and let the deputies know the customers are ready to, lack of better words, it appeared to me they were starting to want to fight with the film guy, and it just seemed like they were going back and forth.
Were some customers upset by the fact that someone was filming inside?
Yes,
And just to clarify, were you involved in the drafting of the tax collector's video recording policy?
no, not at all.
No further regret.
Next witness.
County calls Deputy Jesse Wilcox. You're just sworn. Could you please state your name?
Jesse Wilcox.
And sir, where are you employed?
I'm employed by Pasco County Sheriff's Office.
What was your position with the sheriff's office?
I'm a deputy patrol.
As a patrol deputy, what are your general duties and responsibilities?
Respond to calls, go where we're needed for
Okay.
different things.
Going back to September 3rd this year, were you dispatched to a call at 4135 Land Lakes Boulevard in Pasco County?
Yes, sir.
And what is that location?
That is the tax collector's office.
Is that their Land Lakes location?
Yes, sir.
And what was the nature of the call?
It came out as an unwanted guest,
Okay.
and then it turned into a trespass.
Okay. When you arrive, is there any other law enforcement presence on scene?
No, I was the second to arrive right behind the first responding deputy.
Okay. And what did you observe and what did you do when you first arrived?
When I first arrived, Deputy Bowles and I walked into the tax collector's office where we could hear some people beginning to argue, and there was a little bit of a roar. And we then went to the back and spoke with the staff at the tax collector's office to try to understand what was going on.
Okay. And when you made contact with staff of the tax collector's office, what did they advise you of?
They advised that somebody was in there filming, and they were not supposed to be filming.
Okay. And at the point of your arrival, had they already stopped serving customers?
Yes.
Okay. You briefly mentioned for some of the customers, some of the citizens, were they upset over everything going on?
Yes.
Did the issue with the upset customers escalate to the point that additional law enforcement had to be called to the scene?
Yes.
While you were on scene, did you eventually make contact with the respondent, Mr. Cougar?
Yes.
And during your contact with him, did it appear, and well, let me stop. Was your contact with him inside the office or outside the office?
I spoke with the first time inside the office.
Okay. When you made contact with him inside the office, did it appear that he was video recording?
Yes.
Okay, how could you tell?
The way he had his phone on a tripod in front of him, kind of same as somebody else would be filming.
Consistent with someone who would be recording for your experience? Okay. And so, Mr. Ranker, for the record, we have the copy of the video that we played a brief bit of. We intend to incorporate that as part of the record. So I didn't ask previously, but I asked that that video be incorporated into the record as Exhibit F.
You have any objections?
No objections.
Could be admitted, no objections as county's exhibit F.
Alright, I'm now going to show you what's been marked for identification identification purposes as County's Exhibit G. Do you recognize that?
Yes.
What is that?
That is body cam, that is my body cam. That is a snapshot from my body cam footage.
Okay, and is it a snapshot of your body cam footage from that day?
Yes, sir.
And what does it depict?
Depicts, Mr. Zachary.
Okay. And what's he doing in this snapshot?
What I believe he is, filming.
Okay. County would ask to introduce the photograph into evidence. The snapshot is County Exhibit G. Am I correct?
Yes, it'd be admitted as county exhibit.
Okay. And did you personally, later, verify, via the respondent's YouTube channel, in fact, that he was recording inside that thing?
Yes.
You observed the video yourself?
Yes, sir.
Okay. While you're on scene, at some point, did the tax collector himself, Mr. Fasano, arrive on scene?
Yes.
And when Mr. Fasano arrived, did he make the decision to shut down the office?
Yes.
Did he also request that your agency issue a trespass warning?
Yes.
Okay. As part of that process, did you take a written statement from Mr. Fasano?
Yes.
Show you what's been marked for identification purposes as County's Exhibit A, previously provided to the respondent. You recognize that?
Yes.
Or what is that?
This is Mr. Fasano's written statement.
Did you take that as part of issuing the trespass warning?
Yes, sir.
Okay. County would seek to introduce the written statement and evidence as County's Exhibit H. Approach.
Yes, it'd be admitted as county exhibit.
Did you also, as part of that process, issue the formal trespass warning for the respondent?
Yes.
Personally delivered that to him?
That would be great.
Show you what's been marked as County's Exhibit I and previously provided to the respondent. You recognize that?
Yes.
What is that?
This is the, trespass warning I provided on scene.
Approach.
Yes,
County would seek to introduce Exhibit I and evidence.
admitted as county exhibit.
Okay, at the time that you made contact with the respondent and issued that trespass warning, did he identify himself by his last name?
No, he did not.
Okay, so did he only identify himself by his first name?
Yes.
Right, did you later, were you able to later, identify him, by his full name and, demographic information?
Yes.
Based on that, as well as correcting, any other issues on the original trespass warning, did you then follow up and fill out an amended trespass warning?
Yes.
And did your agency send an amended trespass warning to the respondent via certified mail?
Yes.
Approach you with what's been marked for identification purposes, County Exhibit J, do you recognize that?
Yes.
How do you recognize that?
This is the amended trespass that was sent to him after the correction was made.
Okay. At this time, the county would seek to introduce Exhibit J into evidence, if I may approach.
Yeah. Be admitted as county exhibit.
I have no further questions for this witness.
I'm sure you have questions for this witness.
Yes, I do. Alright. Can I just call you deputy?
Yes.
Alright. Deputy, did you personally see an active recording indicator on my phone screen?
No, I did not.
Did you see a timer or red dot confirming active recording?
No, I did not.
Did you hear any audible indicator that a recording was in progress?
No, I did not.
Before issuing the warning, did you receive a contemporaneous written witness statement describing the facts?
Yes, I did.
Did you rely primarily on staff statements rather than your own observation?
Can you rephrase that?
When you were doing your investigation upon arrival and throughout the incident, did you rely mostly on what the staff was like the staff statements, or were you doing that? Excuse me. Let me just rephrase it here again. Were you relying primarily on what the staff was saying throughout your investigation rather than your own observation?
No. My investigation, it was both the way you're holding your phone, which is consistent with usually recording that way, and then I also used what staff was saying.
And I believe I heard you earlier, you said that you came in immediately following or preceding Deputy Bowles.
Yes.
Do you recall that irate customer who was raising his hand and asking the rest of the customers in the building, are you guys okay with this gentleman recording?
I remember there was a lot of people that were getting irate. I can't remember a specific one. I also remember from the video that we saw briefly that one.
Yeah, that was the gentleman. Were you standing present next to Deputy Bowles when he was de-escalating that situation with that gentleman from the video raising his hand?
I don't believe I was. I know he was talking to some people and I was talking to other people, trying to de-escalate different situations that were going on.
Okay, but you don't recall like what was said specifically with Deputy Bowles de-escalating that specific gentleman?
No, I don't know what Deputy Bowles had said.
Are you aware that Deputy Bowles told a member of the public that I had a right to record?
I do not know if he said that. I can't speak on his actions.
Are you aware of anything relating to him telling me that I had a right to be there and that I was aware of the law?
No, I don't know what he said. I was dealing with other individuals in the tax collectors at that time.
With just your personal observation, who caused the disruption in that building?
The disruption was because you were filming and it was upsetting other people that you were in there filming.
Based on some of the actions of some of the other customers in the tax collector's office, would you say that they were exhibiting any signs of or behaviors that would be considered disruptive?
Can you say that again?
Were there any other members of the public that you observed in the tax collector's office that exhibited any sort of behaviors that could be seen or construed as disruptive behavior?
Not that I can remember.
Are you aware of the term or phrase eliciting a response?
Yeah, part of it.
What is if you had to define it, what would you say what it is?
It's somebody trying to do something to upset others to get a response out of it.
I would agree with that. The gentleman who was raising his hand and asking everyone else in the building if they're okay with me recording in an irate way, would that be considered disruptive?
Objection, he's already testified that he has no personal knowledge of that gentleman. I'll let you answer.
Rephrase it again, or restate it for me.
The gentleman who was raising his hand and asking everyone in the building while yelling irately, asking if what they were doing, what I was doing was something they would approve of. Would you consider that eliciting a response?
I mean, he's asking for a response, but I don't think it was to the degree of being disruptive.
Did you witness any? Did you witness any other members of the public that day raising their voices to a level that might be seen as disruptive or irate?
I'm going to object to continuing this line of questioning that there's a lot of discussion, a lot of talk about whether or not it was disruptive. But disruptive conduct's not, it's not an element of the ordinance, it's not anything that the trespass was based on. The trespass is based on violating posted policy, whether it's disruptive or not. So I think we're getting a little too lost in the weeds on that issue of whether it was disruptive or not.
Based on, once services were shut down and everyone was told to go outside, did you observe each and every customer being treated equally as far as being let back in the building to continue services?
People were extra relevance.
And where are you getting at with this?
It's a matter-
Relates to the trespass issue to you.
It's a matter of discrimination, and being allowed to continue my business as opposed to other people being allowed to conduct their business, which is equally legitimate as my business there.
Okay, you can go ahead. Restate the question, please.
Were all customers treated equally upon being let back in the building after everyone was kicked out by the
Yes,
DMV?
people were being let back in by the tax collectors.
I'll say that again.
I said that people were being let back in by the tax collectors.
And was each and every customer treated equally in that respect?
I don't know, at that point I was standing outside and people were slowly getting let back in.
Did you witness me trying to get back into the building?
I did not see you try to get back into the building.
At what point did you, or let me back up, did you hear anybody or did anyone tell you that they wanted me to leave the building entirely?
Yes, it was, Mr. Hunter. We had spoke with him and he said he had told you to leave due to your recording.
At what point did this conversation happen?
This was when me and Deputy Bowles first arrived on scene.
When you guys went in the back?
Yes.
All right. Did you ever witness him actually telling me to leave? Personally, directly?
I can't recall if there was a moment that somebody had told you to leave or not.
And again, you didn't witness or remember hearing Deputy Bowles referring to me at all when talking to any customers in the building?
No, I did not hear any of that.
Okay, no further questions.
Redirect.
Just briefly, when your agency's asked to issue a trespass warning to someone on public property, it's fair to say that you respond after the alleged conduct or alleged violation has occurred. Yes. Your investigation is often based on collecting statements from staff of the office and folks that had been there prior to your arrival. Yes. Okay, and then I just want to clarify, you were asked about when all customers were outside and only certain folks were being let back in. At that time, that tax collector already initiated the process of requesting that Mr. Cooper be trespassed from the building? Yes. No further questions.
All right, next witness.
County calls Danielle Rowell. We can say there, she was not sworn, but she gave the oath, but I can bring up real quick. Yes, please. Raise your right hand. Swear to tell the truth, the whole truth, nothing but, something you can help you, perjure, so help you God.
I do.
Okay, please state your name.
Danielle Brown,
Ms. Rowell, where do you work?
Pasco County Attorney's Office,
And what is your position with the Pasco County Attorney's Office?
paralegal.
Okay, as a paralegal, are you responsible for mailing notice of hearings for trespass appeal hearings?
Yes,
Okay. In this particular case, with his trespass appeal, did Mr. Cooker provide a email address?
yes,
Did you email him a copy of the notice of hearing for today?
I did.
With that notice of hearing, did you also provide a copy of the amended trespass warning that was introduced into evidence?
I did.
And did he acknowledge receipt of those documents?
Yes.
We're on K, is that right? Alright, I'll show you what's been marked as county's exhibit K. Do you recognize that?
Yes.
What is that?
It's an email confirming receipt of the amended trespass warning.
County would seek to introduce exhibit K into evidence, if I may approach.
Yes.
No further questions?
It is county's K. Do you have any questions, Ms. Brown?
Yes. Are you, in your position, do you have to familiarize yourself with police or law enforcement procedure as it relates to trespass?
No.
No further questions.
Are you redirected?
No, sir.
Next witness.
County would rest at this time.
Alright, Mr. Kruger, this is your chance to call witnesses and to testify yourself and introduce evidence. Do those in whatever orders you want.
Alright. Just proper way, proper start with our opening statement. I know we already went over the reservation of rights earlier, but I'll just read this short part first. Before proceeding further, I respectfully note, for the record, that I object to being barred from raising constitutional issues at this hearing. I expressly preserve all constitutional claims, including my First Amendment rights and related case law, for review in court of law. I'm here today to address the ordinance and procedural compliance issues within this forum, but I do not waive or abandon my constitutional arguments. So my opening statement is this. Good morning. My name is Zachary Cooker. I'm here to appeal the trespass warning issued against me on September 3rd, 2025 and amended on September 12th, 2025. This hearing's purpose is to decide whether the warning was issued in compliance with Pasco County Ordinance 66-159. The ordinance imposes mandatory predicates, a specific rule citation, a contemporaneous written witness statement, and a county burden of proof by preponderance. I will show those predicates were not met. First, the warning cites no specific statute, ordinance, or posted rule. Second, there is no contemporaneous written witness statement predicating issuance. Third, the evidence does not establish that I engaged in disruptive or unlawful conduct. Staff elected to suspend service, and that office decision, not my conduct, created the interruption. Finally, the one-year exclusion is disproportionate and denies me access to essential services. For these reasons, I respectfully ask the hearing officer to rescind the warning or at minimum modify it to allow access for legitimate government business under reasonable conditions. So Pasco County Ordinance 66-159 governs trespass warnings on public property. It requires 1, an identifiable violation linked to a specific law, ordinance, or posted policy. 2, a contemporaneous written witness statement presented to law enforcement before issuance. And 3, proof by preponderance of the evidence at this appeal that those predicates were satisfied. These safeguards prevent arbitrary exclusion and ensure that citizens receive notice of the rules they are alleged to have violated. Absent a specific citation and a contemporaneous written statement, a warning is defective on its face. So main arguments here: A, burden of proof, appearance is not evidence. The county bears the burden. A phone in hand does not equal recording. No direct observation shows an active recording indicator, timer, or camera app. No audible cue was heard. Without reliable proof, recording is conjecture. If the county later produces a video from the internet, that does not retroactively cure missing predicates at issuance. The question is whether at the moment of the warning the ordinance's requirements were satisfied. They were not. Also, I'd like to point out that the first officer that we heard from, Deputy Wilcox, stated that Deputy Bowles was the first right before Deputy Wilcox's arrival to the tax collector's office. Deputy Bowles, in the presence of Wilcox, and this is captured on camera, standing right there listening to Deputy Bowles explain to the irate customer while de-escalating the situation. He was actually causing a disruption, not me. It was explaining to him that I had a right to be there and that I was law savvy, that I understood the law in the regard of what I was doing there. So that would lead anyone to believe, any reasonable person to believe that, hey, if law enforcement's saying that what I'm doing is perfectly fine, I have a right to be there, that would lead me to believe that I can continue to do what I was there to do. I would also like to point out that I don't recall anybody asking me to leave the building. I do recall them telling me or asking me to stop recording, and that they were calling law enforcement. So I waited for law enforcement. When law enforcement arrived, Deputy Bowles made it clear that I had a right to be there, and it sounded like he was going to protect my rights, as law enforcement does. They don't enforce policy, they enforce the law. B, procedural defects, no specific rule, no written statement. So the warning lacks a specific citation to statute, ordinance, or posted policy defeating notice and review. The ordinance also requires a contemporaneous written witness statement before issuance. None has been produced. These are core requirements, not technicalities, and their absence invalidates the warning. C, staff caused disruption, not attributable to me. So staff chose to shut down service. That decision, not my conduct, interrupted operations. The ordinance requires that the person warned unreasonably interfere with operations. The evidence shows I did not. And D, disproportionate and untethered. 1 year exclusion is excessive and not narrowly tailored to any operational need. If any restriction were justified, it should be the least restrictive measure consistent with operations, not categorical ban from essential services. And then E, selective enforcement. If others engaged in comparable or more disruptive behavior without being trespassed while I was excluded for allegedly holding a phone, enforcement is not even-handed. Such selectivity undercuts credibility and weighs against upholding the warning. All right, so some of the things that we heard today, we've heard repeatedly from at least, from multiple witnesses that they're saying that I was the disruption or the cause of that disruption. That was even confirmed when I was there. I spoke with Sergeant Duncan. He was the first to kind of change things from, oh, you have a right to be here, to all of a sudden, yeah, we're going to trespass you because you're being, what you're recording is the disruption. But again, like I asked the sergeant there, and the questions I've asked some of the witnesses, what caused the disruption? They were saying, well, it's the recording. Well, if they just would have complied with the state law, namely Chapter 119 of the Florida statutes, and just got me in and out of there, none of that would have happened. The fact that they kept me there and dug in their heels, doubled down, and did not comply with the state law, it led to people becoming irate, but only once they shut down services. Prior to that, there was like maybe one person that said something about my recording, and then I de-escalated it, but aside from that, I mean, the disruption was coming from people not being able to conduct their business, and that was solely based on the decision of the tax collector's office, because I can't stop them from conducting, a camera cannot stop, business in a DMV. And I was standing in a public area, so the onus is not on me to, I didn't design the building the way it was, so I'm just going into the public areas. So staff chose to halt service. That office decision created interruption. The ordinance targets conduct by the warned person, not the office's own shutdown. And then the recording theory. Appearance is not evidence. Even if a recording exists, the county still failed to cite a specific rule and obtain a contemporaneous written statement at issuance. The 1 year duration remains disproportionate. There's some case law here that I'd like to put on the record here. So you have the Smith v. City of Cumming, which is out of the 11th Circuit, covers the entire state of Florida. It's the right to observe and record. So the 11th Circuit recognizes the First Amendment right to gather information about public officials and public spaces, including recording. Smith does not excuse disruption, but it rejects the notion that cameras are per se prohibited. Recording is protected activity subject to reasonable neutral limits tied to operations. So as long as you're checking off all the boxes for time, place, manner restrictions, which I was there within hours of operation. We know now that I was recording in a public space and that I was doing it in a manner that was polite, professional, and low-key.
Do you have copies of the cases with you?
I'm sorry?
Do you have copies of the cases you're citing with you?
I don't, but I can give this to you once I read it. And
Do
then,
you have the key site number, the number of the,
what do you mean?
case?
I can give me the names of the cases.
Or the names of the cases, and then generally there's a number that's associated with it? If not, just give me the names again.
The names is all I have right now. It's Smith v. City of Cumming.
What's the city again? I can't hear you.
City of Cumming.
Okay. What court is that case from?
What, sorry? Oh, the Supreme Court. Sorry, this is out of the 11th Circuit, like I said.
Alright.
And then the second one is Brandsburg v. Hayes. And that's U.S. 1972. Third one is Price v. Garland. That's D.C. Circuit. And then the final one's Patrick v. McGuire, ND, Florida, 2024.
That's one that the county attached to their
That's
packet?
correct. Yeah, that's correct.
Okay. Sorry, I didn't mean to interrupt, but you can proceed.
No worries. Should I start over with the Smith v. Cumming?
Wherever you left, wherever I interrupt, it's fine, yeah.
Sure. So Smith v. the City of Cumming, again, that's how the 11th Circuit covers the entire state of Florida. That has to do with the right to observe and record. So the 11th Circuit recognizes the First Amendment right to gather information about public officials and public spaces, including recording. Smith does not excuse disruption, but it rejects the notion that cameras are per se prohibited. Recording is protected activity subject to reasonable neutral limits tied to operations. And then moving on to Brandsburg v. Hayes. It has to do with equal access for press and public. So Brandsburg affirms that news gathering has First Amendment concern and that the press has no greater access than the public and vice versa, and no fewer rights either. Where the public may go, a citizen engaged in news gathering may go, in other words, a citizen journalist. Government cannot single out a person for exclusion merely because he documents his interaction, which is what I was there to do, interact my interaction, or conducting my business. Next one's Price v. Garland, that's DC Circuit, recording as speech creation, reasonableness. So Price treats recording as part of creating speech and upholds viewpoint neutral, reasonable rules on government property where justified by operations. The case does not treat recording itself as a disruption. Reasonableness requires neutral, tailored enforcement and adherence to procedures, steps missing here. And what I was doing is not even expressive. What I was doing there at the tax collector's office was simply to, it was essentially a modern way of taking notes, documenting my business, legitimate business there. And then Patrick v. McGuire, distinguishable procedures still control. Even if some recording limits are permissible, Patrick does not excuse non-compliance with 66-159. Time, place, manner limits must be implemented through proper procedures and proportionate remedies. Those were not followed. Could I I can call any witness at this point?
Yes, you can.
Alright. So there was a gentleman that was at the, one of Mike Fasano's tax collector's offices as well, doing the same exact thing, pretty much that I was doing, and had a hearing previously. John, would you like to talk about your experience and some of the inconsistencies thereof?
Yeah, I mean, I agree. I guess, what is the relevance of?
The relevance is that he was in the same exact kind of hearing that we're doing today, and he won. And I would like him to just talk about or ask him questions about how he, what arguments were there that led to his winning his trespass appeal hearing.
Just respond that every case is unique. I recall that case, I represented the county on that case. My understanding of the order was that the county was unable to establish that Mr. Felix was actually recording inside the building, therefore insufficient evidence that he violated the policies. What happened in that case? I'm just not sure what it has to do with this case.
I mean, I tend to agree. I remember that case as well. I read the order on that case. I'll give a limited amount of time just so you can be heard, but I don't want to spend a bunch of time on it because I'm familiar with it.
Alright, thank you.
Check.
Did you take the oath when you were present for the oath? Did you?
I'll do it again if I need to.
Okay.
Raise your right hand. Do you swear or affirm that the testimony you are about to give in this hearing is the truth, the whole truth, and nothing but the truth?
I do.
Alright, Mr.
Sorry,
Felix.
state your full name.
My full name?
Yeah.
John Felix.
Alright, Mr. Felix, which tax collector's office were you in that case where you were found not guilty?
Well, I went to the Wesley Chapel. That was the Wesley Chapel. And they claimed I was recording, even though I wasn't recording. And they went through all this hoopla anyway, so it's more about, we don't want your kind in here more than you recording. It's, people don't like to be recorded. It makes them uncomfortable. So they threw a policy on the wall, and the commissioners have given them the platform to write anything they want on a piece of paper, whether it's no cameras or a certain skin color or religion. They can write anything they want on a piece of paper, and they're willing to use 14 cops in this situation to bring it to a halt, as if, like, they treated this incident like it was a school shooting. He literally went in there.
I object to a witness making an argument on behalf of.
I was there.
Alright,
Personal first-hand knowledge.
you have specific questions, you can ask those, but.
Was it ever communicated to you that no matter what was on the policy, that they would enforce whatever that may be, whether you had a certain skin color or
Correct.
wearing a certain color shirt, or they
Yes.
have the right to enforce that ordinance or policy no matter
Yes, it was articulated in this court when I was cross-examining a deputy that if they put up a piece of paper that said no black people, that the deputy would still have to come and trespass that person for being black. No questions asked, the way the ordinance is written.
And
And that's how it's being translated by the people who swore to preserve, protect, and defend our constitutional rights.
Do you have any questions of Mr. Felix with regards to the incidents that we're here on today?
yeah, my next question is, going back to the incident at hand that we're here for today, Mr. Felix, what did you observe once everyone was kicked outside? of the tax collector's office.
Once everybody was outside, they started selectively letting people back in one at a time. And when he tried to go back in to conduct his business, they physically blocked him from re-entering and conducting his lawful business, thus discriminating against him.
Were there any law enforcement officers out there that shared their same view as you?
Absolutely. There's at least 14, if not more, with at least 10 or more SUVs. Again, it looked like a school shooting was about to go down when it was literally a guy holding a phone making a public records request.
Do you recall the name of any law enforcement that was agreeable to what you just stated?
Say that again?
Was there any law enforcement that, by name that you can recall that shared or communicated with you that they agreed with what we were doing there?
I don't know him by name, but yeah, there was a couple cops there that said there's way better things we could be doing than being called to the tax collector's office because a guy is recording. They want to solve crimes. And they don't like the fact that Mike Fasano is using them as a personal army against people that he don't like their kind.
Was there anything else that you witnessed firsthand once you arrived or throughout the entire exchange that you were involved in once you everyone was kicked out of the building?
Yeah, I saw a bunch of people yelling at you and disrupting you. I saw that.
Did you see anybody else getting reprimanded or asked to leave or treated like they were treating me simply
No, I saw.
for being disruptive or raising their voice or being argumentative or?
No, I saw you with your typical calm demeanor. This is how this gentleman is. I can't even, I've never seen this guy mad in the years that I've known him. And if he got mad, I would be scared. So this is basically his demeanor. And everyone else there was more escalated than him. But somehow, he was disruptive, and they were all fine to conduct business. But he was not. Because he engaged in holding a phone like this. That's literally his crime. I don't know how many more of these are we going to do before we figure out this is ridiculous and that the power of the state should not be used to suppress constitutional rights.
All right, well, I don't have any further questions unless there's anything else that you observed during that incident.
Mr. Brown, do you have anything?
Just one thing I want to clarify for the record. You talked about your prior case. You said you were found not guilty.
I didn't say that.
You testified to that 10 minutes ago?
He said it.
Okay, so I guess the question was asked in the case where you were found not guilty, and then you answered the question. I just want to clarify. You were not charged with a crime in that instance.
Correct.
It was an appeal of a trespass warning, and the trespass warning was rescinded.
Correct.
You had a successful appeal.
Correct.
That's all I have.
Thank you. Good.
Yep.
Thank you.
Another witness?
Yeah. What's your name?
Daniel.
Huh?
Daniel.
Daniel what? Morrison. Got Dana Morrison here. I call to the stand.
Sure.
So were you, did you take the oath earlier?
No, I did not.
All right, if you don't mind, I'll have to take that now.
Mm-hmm.
Raise your right hand. Do you swear or affirm that the testimony you are about to give in this hearing is the truth, the whole truth, and nothing but the truth?
Yes.
All right. Daniel, when was the last time you went to the tax collector's office at Lando Lakes?
It's been a while. I can't give you time or day because it's well over a year ago.
Okay, it was less than 2 years though.
Yep.
Okay.
With that in mind, I'm going to object. It sounds like he wasn't even present for the date in question. So
Yeah, so it has to do with showing the consistency or the, like the consistency of the ordinance being followed, towards all persons that are viewed as violating the ordinance or policy at the tax collector's office.
Is this the same situation with the video that you showed earlier that
It is,
was before, the ordinance was changed, or the policy was changed?
that's correct.
I'm gonna agree that it's not relevant. If he has something to add relative to your incident, I'll be happy to hear it.
Did you view the video of
Yes, I did.
the incident that took place of mine?
Yes, I did.
All right. Did you see, was it Jerry Hunter in the video?
I don't remember vaguely about seeing him. I just know that you were trespassed again for using a camera.
Did you ever recall in the video of me being asked to leave?
Yes.
Not to confuse being asked to leave with asked to stop recording.
Right.
So did you hear them ask me to stop recording?
Yes.
Did you hear them say that they were calling law enforcement?
Yes.
But you did hear them ask me to actually leave the building?
I don't recall. I would have to, again, refer back to the video itself to.
Okay. I don't have any further questions, but could I proceed to show timestamps of the video?
Hold on just a second, with regards to this witness?
No, I'm done.
Do you have any questions of this witness?
Just very briefly. So, sir, you testified that you viewed the video of this incident. Just to clarify, because obviously there's an alleged video that Mr. Cooper took. There's body camera footage from law enforcement. Which video are you referring to?
It's
Okay. The respondents.
in his video.
From viewing the video, do you have an opinion as to whether or not he was recording inside the tax collector's office that day?
Was he recording inside the tax collector's office?
Yes.
Yes, he was.
No further questions.
All right, all set. And then I wanted to show the video relating to a handful of timestamps that show, like for example, Deputy Bowles explaining right in front of Deputy Wilcox, who is one of the witnesses here, stating that I have a right to be there in the tax collector's office, and that I was knowledgeable on the law.
Since the full video has been admitted into evidence, I wonder if it might be most practical to, if he has the timestamps, we can put it up on the big screen.
Yeah.
I'm okay with that.
It's good with me.
We have the sound going though.
Is there a sound?
We're having an issue with the sound trouble. Maybe it's on the computer, we turn it all the way up. Put the microphone on too. I don't know if you can hear that.
Yeah.
Really?
Why is it so low?
Yeah, that's good.
Welcome back, Liquor Controllers. We're in Pasco County, over here at Mando Lakes. We're about to go into the D&D where John Felix himself
legend.
Alright, first, can I stand at the podium so I can be heard a little better? Alright, can you guys hear me okay? Alright, let's go to timestamp 26 minutes and
was assaulted by a guy. The cops came and arrested that guy.
26 minutes, 11 seconds.
Shut down the team back then too, because they have this unconstitutional ordinance in Pasco County that says if you go into a team.
Twenty-six.
26 minutes, 11 seconds.
Is there a way to make that audio a little bit louder so you can hear Deputy Bowles?
I'm sorry, nice to meet you. CACH like Zach? Correct way?
Was this whole video been introduced in evidence, right? So I'll have a copy of it.
I'm staying over here for the most part. The only time I turn the camera in.
Alright, we can go back to 26 minutes and 10 seconds. Happens right away when you see Deputy Bowles saying I have a right to be there. Alright, can we go ahead and pause it? So, I don't know if you can hear that, but Deputy Bowles de-escalates that gentleman saying, you know, referring to me that I had a right to be there, and told this gentleman right here who is not particularly fond about me exercising my right to record, tells that guy, Deputy Bowles tells that guy that he's not being forced to stay at the DMV, that indeed he can leave if he wants to, and then proceeds to say that, you know, again, referring back to me, saying I know the law as relates, you know, obviously to what's going on here, and reiterates, you know, hey, if you don't want to be here on camera that bad, you could just leave, you know, no one's forced you to stay here. So that indicates this is the very first contact with law enforcement during this whole fiasco, and you know, the very first thing the very first officer said to me was, I have a right, you know, to do what I'm doing. So
So this what you're showing here, is this from the photo that was introduced earlier, the body cam footage, or is you with sunglasses on holding strike bar or stand with the phone?
I'm not sure if it's around this timestamp, but it's definitely I'm standing in that area. So
that's what this is from, that phone on the.
Oh, yes.
So you don't dispute that you were recording in that?
No, I don't dispute that. I'm just saying that at the time of issuance, they have to be able to confirm or prove that that indeed was what I was doing with my phone. Just simply appearing to record and then issuing a trespass at that time and everything without being able to confirm that is not just a technicality issue, but it's like I said earlier, it's not complying with the procedure of the ordinance there.
Yeah, I don't know if I agree with that, but I'm gonna review the policy.
The next timestamp I'd like to go to, if I may, is also I do want to point out right here that you see Deputy Wilcox. He was standing next to Deputy Bowles the entire time I questioned him during the witness questioning or cross-examination, and he didn't recall if he was there or that he heard what Deputy Bowles was saying. But obviously, he's standing right there as he's explaining or de-escalating to the other customer here about what I just showed. the next timestamp I'm gonna go to is 4 minutes and 33 seconds.
Before going to the tax collector that day, did you ask for permission to record with inside the office?
No, sir. Alright, so before we hit play, this is basically, has to do with me, my interaction with Jerry Hunter. He tells me to point my phone camera at myself, indicating that I could indeed record as long as it's pointed at me. So, no, on the actual video, can we start over at 4 minutes and 33 seconds?
Sorry.
Can we just start over at the 4 minute 33 seconds?
Well, if there's no recording, then I can't record even if it's on myself, right? I didn't say it was on or off. I'm not saying it's recording. Well, we can get back to that. Can I just get the business card I can ask for? I'm also gonna submit public records.
Alright, hit pause. So I was there to submit a public records request. He couldn't get over the fact that I may have been recording, and I explained to him that I'm not saying if I'm recording or not. Never disclosed that at the time. And he says, well, can you point your camera at yourself, indicating like any reasonable person would be like, okay, well if I turn the camera on myself, that assumes or begs the question, you know, that I can record as long as I'm facing the camera on myself. Again, would indicate another inconsistency in the prohibition of the ordinance regarding recording. It seems like they just kind of make up, you know, rules on the fly. And then a couple more here. So if we could go to 10 minutes and 18 seconds, please. So in this one, Jerry Hunter explains to the customer that they can't serve them because of the suspicion of recording. This is where I argue that the disruption really is coming from the action of shutting down. But
So you're refusing to take my public records, right? You can still serve me. You can still serve me, sir. Go ahead and start that.
alright, pause it there.
Alright, so I got you refusing to take that.
So I even tried to plead with him, like, or tried to tell him, like, no, don't even start that. Like, you can serve the rest of the customers here. My camera's not stopping, you know, you guys from serving the rest of the general public who are there for services. And they made the choice, they made the conscious decision to shut down services. And yet they say I'm a disruption, but I think it's clear that, you know, if you watch the video in its entirety, you would see that people don't start getting really irate until, you know, they can't proceed with their services. Now, if we go to 31-minute mark in 6 seconds, I'm going to show Deputy Bowles' request that I stand in a specific area and I reasonably comply. to try to meet in the middle, you know, where possible. So this is to show basically that I'm being reasonable and working with law enforcement to find some sort of middle ground to de-escalate and get to a point where I can get my business done. Again, that's 31 minutes and 6 seconds. That's fine right there. Alright, you can pause there. So that was just to show that I was meeting in the middle with law enforcement and listening to, you know, reasonable directives so as to, you know, not be a part of the escalation that was happening due to services being shut down by the tax collector's office. And then if we can go to the 25-minute mark and 25 seconds. This one, a customer gets disruptive and he's never kicked out.
Was it 25?
Yeah, 23 is fine. Close enough.
That is not the law.
Raise your hand if you're okay with this guy videotaping everybody. If you're okay with it, all right, well, that's perfect.
Amen. Freedom is scary. Freedom is messy. Amen. Yep.
Is anybody else okay with this? I'm not seeing that. At this point, this is like a gas thing. Like, you need to leave.
Yeah, we're a republic. We're not a democracy. This is a democracy.
It's my privacy.
This is my right.
It is my privacy.
Doesn't
It's my right.
You don't have privacy in public. You're in public. You stepped outside your house. You decided to walk into a limited public forum. This is a public forum. Whether you like it or not, sir, we live in the United States. We're going to abide by the Constitution. So.
Yeah, and you know what? There's people
All right, you
that
can pause there.
protecting our privacy.
Well, then they can do that too.
And that's where Deputy Bowles comes in, which I showed you, and says I have a right to be there and so on. But this is just one occurrence of another member of the public getting irate and causing a disruption. That was a perfect example of someone trying to elicit a response and create a mob situation. It kind of backfired on one, as you can see, because there was somebody else in the, who was part of the public out there that said, yeah, I'm okay with it, freedom is scary, freedom is messy. And then he tried to get others to join him, which didn't really work, but there were multiple occasions where someone created disruption, tried to elicit a response, and it was all in spite of me. I'm sure nobody would argue for someone who's like, there are people who are terrified of law enforcement out there, or they get nervous when law enforcement's around, and if they act out when law enforcement's around, we can't attribute that to law enforcement being the disruption. We would apply that disruption to the person creating the outburst who are yelling things like F the police or whatever. You know, it's not the police's fault for someone else's, who should be responsible for their own actions. So my actions there that day, you know, were to simply conduct my business and call it a day. It probably would have been a 5 to 10 minute, you know, occurrence tops, but it ended up being, you know, an hour-long incident due to having to wait on law enforcement, being told by law enforcement he has a right to be there. I had a right to be there. I knew the law, blah blah blah. It wasn't until supervisors, law enforcement supervisors, got involved and kind of changed things around and enforced a what I would call an unlawful trespass, because law enforcement there to uphold the law and honor their oath to the Constitution and protect my rights, not some bureaucratic ordinance or policy, that would come in direct violation of said Constitution, which is still the supreme law of the land. That's all the video that I wanted to show. I'm gonna have to go back over here real quick so I can read my other stuff. Sorry, just give me one moment. Alright, so my closing statement is, hearing officer, the county has not carried its burden. The warning lacks a specific rule citation and a contemporaneous written witness statement. The alleged disruption was a staff decision to halt service, and the 1-year exclusion is excessive and untethered to an operational need. The ordinance's safeguards exist to prevent arbitrary exclusion from public facilities. Because those safeguards were not followed here, I respectfully request rescission. Alternatively, please modify the warning to allow access for legitimate government business under reasonable conditions, such as like what you would have at any other public building for time, place, manner restrictions to document using a camera, if you will, to do so. Thank you.
Mel, did you have anything?
He did make himself a witness. I just want to question on one subject matter. Mr. Cooper, and you can stay there if you want. It's up to you. So you read the 66-159 in preparation for the hearing, correct?
Right.
Okay. You would agree that there's nowhere in there where it says that one of these government offices, like the tax collector, that they can ask someone to be trespassed for being disruptive, correct?
Say that one more time.
I can rephrase it. Is there, from your understanding of the trespass ordinance, does it say that someone can be trespassed for being disruptive?
I don't recall.
The ordinance is in evidence. I mean, I'll tell you,
Sure.
it doesn't. It says you can be trespassed for violating any rule, policy, or directive on any sign of the property, for violating any law or regulation. And then the only one that's a little different there is by using language which by its very utterance inflicts injury or tends to incite an imminent breach of the peace. So, I mean, I guess, would you agree that using using language that inflicts injury and incites an imminent breach of the peace, that's a little bit higher of a standard than just being disruptive, right?
Correct.
So the gentleman that was on the video that he raises his hand or ask everybody to raise your hand if you're okay with this guy recording. Whether they like it or not, there's really nothing in the ordinance that authorizes the tax collector to ask that gentleman to be trespassed, right?
Not that I'm aware of.
Right. The ordinance says you can be trespassed for violating a posted policy. Would you agree they have a posted policy about video recording, whether you like it or not, they do, right?
They do.
And they asked for you to be trespassed in this case for violating that policy.
They never asked me to leave while I was inside.
Well, they asked the sheriff's office to issue a trespass warning to you, correct?
Correct, and at first they were actually protecting my rights.
Or the sheriff's office. To your knowledge, or any of those other citizens who may or may not have been disruptive, were they video recording in the tax collector's office?
Not that I'm aware of. Well, there was one other person outside once everyone was shut. Once the tax collector's office was shut down, there was another individual outside recording.
Well, I'm asking about inside.
Not that I'm aware of.
I don't have any.
Actually, no. Actually, there was. There was an individual that I caught on camera recording me at one point towards the beginning of the video. They never asked him to leave.
Perhaps it didn't catch their attention.
Perhaps.
I have no other question.
All right, you have anything else you want to add based on what he asked you?
Isn't it considered an improper trespass if you haven't even been asked to leave?
Do you guys contend that question?
Yeah. Sorry. Is it? Let me rephrase. Sorry. Is it an improper trespass or incomplete trespass to try to trespass or enforce a trespass on someone when they haven't been asked to leave?
So I'm not a witness, but I'll address that in argument.
What was that?
I'm not a witness, but I will address that in my argument.
Okay. Do you have anything you want to testify to based on the questions that he asked you? Anything different than what you've already said?
Am I missing anything? I think I've asked everything, or said everything that I needed to say.
Okay. And, all right, we'll proceed with county's argument then.
So, I think this case that's here today is very straightforward. Mr. Cougar has brought his appeal pursuant to 66-159. He said it earlier, he's right, it's in subsection 6K, the government bears the burden of proof by preponderance of the evidence that the trespass warning was properly issued pursuant to the criteria of the ordinance. It's not a beyond a reasonable doubt, it's a preponderance of the evidence, and more likely than not. So really the only question for this tribunal is, was the trespass warning properly issued pursuant to the ordinance? And that procedure is governed by 66-159 subsection 2. I think I'll address right now the point he just made. There's no requirement in here that staff ask the person to leave before asking law enforcement to issue the trespass warning. So whether or not they asked him to leave, frankly I think it's immaterial. If they asked him to stop recording because it was in violation of their policy and he refused to do so, that triggers the call to law enforcement, that triggers the request to issue the trespass warning. You'll have to go back and review the video. I don't know if they asked him to leave or not, but I think it's immaterial. I think it doesn't matter. So going through just some of those procedures for the issuance of the trespass warning in subsection 2, the first one is that only authorized personnel may make the determination to issue the trespass warning. In this case, we know from the testimony of both of the county's witnesses that Mr. Fasano, the duly elected tax collector, was the one who made the decision. He's the head of that office. He's clearly an authorized personnel. Subsection 2A goes on to say that authorized personnel may have cause to remove any respondent if they determine the respondent acts in a manner which violated any rule, policy, or directive on any sign of the public property. And I think it's important to note that, like we just talked about with Mr. Cougar, there's nothing in there that says they have cause to trespass you if you're disruptive. So there's been a lot of finger pointing about who caused the disruption. Well, did he cause the disruption by video recording? Did the citizens cause the disruption because they got upset? Were they upset because he video recorded? Were they upset because the office closed? At the end of the day, none of that really matters, right? We've gotten very lost in the weeds on this issue of who caused the disruption. Disruptive conduct is actually not a basis to have an individual trespass from public property. Maybe that's good policy, maybe it's not. It's a debate for another day. But the issue in this case is, what was the posted policy violated? And the policy in this case is the tax collector's video recording policy. There's a sign posted on the front of the building. There's a photo of that in evidence. The entire policy, there was testimony that's posted inside the building. There's also a copy of the policy in evidence. So we've proven that the policy was posted. And really the question at that point then becomes, did the respondent violate the posted policy? Well, I don't think I need to spend a lot of time on that. It doesn't sound like he denies it. We've got the video and evidence. He clearly recorded in there. His own witness gave testimony that he believes the respondent recorded in there. You have the testimony of the county's witnesses, Safety Officer Mason, as well as Deputy Wilcox, who indicated that he was holding the phone in a manner that he appeared to be recording. The screenshot from the body camera confirms that. But we don't need to speculate. The video ended up posted online. I would note today, if you try to access it, it's a private video that you can't access it, but a downloaded copy is in evidence. The video clearly shows that he was recording in there. Now, Mr. Cougar makes some argument that on the day of the warning, well, how did they know if he was recording, and it was just based on his demeanor and their speculation, and they can't issue the warning on that. Well, they made a determination based on what they saw that he violated the policy. Could they have been wrong? It looks like they were wrong in Mr. Felix's last case, but that's the purpose of this hearing. He files the appeal to hold the government to that burden to show, well, prove it. You're going to say that I was recording, prove it. And whether or not they saw the video that day, it doesn't matter. We're here in this hearing, we've proven it. The video's in evidence. So we've proven beyond the preponderance of the evidence that the posted policy was violated. Again, I don't really think he disputes that. Moving on to section 2C of the ordinance, it states that while authorized personnel has to make the decision to issue the trespass warning, the ministerial duty of writing the warning must be performed by law enforcement. So that occurred in this case. Deputy Wilcox testified to issuing it as well as the amended trespass warning that followed. I think it's important to note in that section too that Mr. Cooper made argument that, well, law enforcement never saw recording and they just went off the word of the staff from the tax collector's office. But frankly, the way these investigations work, the way this ordinance is written, that's pretty standard process. It's the decision of the tax collector's office and their authorized personnel to have the warning issued. Yes, he takes statements, yes, he takes an investigation, but at the end of the day, his duty is, even the ordinance defines it, is ministerial. He's just taking the information from them, issuing the warning. That's not to say that he shouldn't do an investigation, but it's commonplace that the bulk of the basis for the trespass is going to come from those employees in the office. The next section of the ordinance is 2D. States the trespass warning must state the facts and circumstances justifying its issuance. So in this case, and I want to talk about the amended trespass warning. I can't even stipulate that the first trespass warning, if we were here just on that, there's probably some deficiencies in there. So I know Mr. Cooper made argument that the trespass warning doesn't state what policy was violated, but an amended trespass warning was filled out. There's no reason the county can't do that. It was sent to him, he received it, and the amended trespass warning very clearly states that the posted video recording policy was violated. The next section of the ordinance is 2F, that the trespass warning must identify the scope of the prohibition by address, parcel ID, or other description. It does, it gives the address 4135 Land Lakes Boulevard in Land Lakes. Section 2G states that the trespass warning may only be issued by law enforcement after receiving a witness statement containing the information in 2A and 2B. 2A is again the basis for the trespass, and 2B is some of the factors they can consider. Both of those things are in the witness statement. The written statement indicates that his conduct was disruptive to business and that it violated their posted policy. The respondent, he made a lot of argument that there wasn't a written statement collected or there wasn't a contemporaneous written statement collected. I'm not sure what he was getting at, but there was. It's in evidence. Deputy Wilcox testified to taking it. Mr. Mason testified to observing Mr. Fasano giving it, and it's in evidence. So they met their duty of collecting a written statement prior to issuing the warning. So, you know, again, the only issue is, was the trespass properly issued pursuant to the criteria in 66-159. It was. I know Mr. Cooper's brought up a couple other issues. I really don't want to spend a lot of time on the constitutionality for the same reasons we talked about earlier. We're not in a court of law that has the ability to make those determinations. But I will, because he touched on it, I'll briefly address the cases that he referenced. Smith v. City of Cummings, that did uphold the First Amendment right to record specifically police activity in public areas meant to be used by anyone and everyone. I think it's a little different when you're talking about a limited public forum such as the tax collector's office that, yes, is open to the public, but for the limited purpose of people coming in with legitimate business to do there. And the other case he mentioned, Price v. Garland, kind of makes that distinction, and more importantly, the Patrick v. McGuire, which actually deals with this very policy itself, exercises the reasonableness and viewpoint neutral test from Price v. Garland. When you're talking about these limited public forums, you know, it's not a free-for-all. They're allowed to do these restrictions. They just have to be reasonable and viewpoint neutral. And we have a federal court in this district that has found that the tax collector does. So I really don't think there's any more merit to that argument. And he did ask, Mr. Cooper also asked about the 1 year prohibition on the trespass. I would just respond that I don't think the hearing officer has any discretion. The ordinance says it'll be for a period of 1 year. I think it's relevant to point out he's not a resident of Basco County, and Basco County has 4 other tax collectors' offices, so he's got reasonable alternatives. The 1 year trespass from the Land O'Lakes tax collector's office. To the extent that he has business to do with tax collectors in Basco County, it doesn't prohibit him from doing so. So we would ask that the trespass warning be upheld.
Do you have any final arguments? This been made argument, but do you have anything to add?
Yeah. So, you know, you mentioned, Smith v. Honey is a limited public forum, so is a DMV. Basically, any place that's open for business, to members of the public, there's right to access to conduct said business that's provided, through the taxpayer. You have the same sort of time, place, manner restrictions, which as long as you're going there within business hours, that's the time, place, you're standing in a public area like a lobby, which is where I was at the tax collector's office, and the manner, you know, I was being calm, cool, collected, articulate, respectful, professional, you could say. You know, it all upholds with Smith v. Cumming. I know that this court is an administrative court, doesn't necessarily get into the constitutionality of things, but again, I'm just stating these things for the record and for persuasive purposes. But you know, if we have a right to record in a limited public forum, and DMV is a limited public forum, then what ordinance or what policy can thwart that? Because the Constitution supersedes all these other flimsy ordinances that, you know, like he said, whether it's written very well, that's an argument for another time. But I just want to state it for the record. And also, give me a second. I'm sure I covered everything. There's one thing I wanted to reiterate that I said earlier. So what I brought up earlier, the recording theory, so appearance is not evidence. Even if a recording exists, the county still failed to cite a specific rule in obtaining contemporaneous written statement and issuance for 1 year. So just wanted to reiterate the first part, that appearance is not evidence. I unpacked that a little bit more earlier in my argument. Also, I received a letter in the mail sometime after the incident from Pasco County Tax Collector's Office, from Mike Pisano. It was a letter to ban me from going back to not only this tax collector's office at Land O'Lakes where the video took place, but also any and all of the Pasco County tax collector's offices. Just thought I'd bring that up and ask, you know, if
You have a copy of that letter with you?
I didn't bring a copy, no, but it basically just it said that I could still partake in services like electronically and likewise, but I just wouldn't be able to go in person and conduct business there. So if indeed the trespass is rescinded, would that also rescind, I guess, or make the ban null and void? That's a question I would have, but I just wanted to bring that up for the record that I was banned from all the different Pasco County tax collectors' offices.
May I add something about that? What he's talking about there? So I was issued the same.
Objection to that? The part for testimony is over, but if you want to add something, go ahead.
So instead of trespassing me a third time in Dade City, what they did was just mail me a letter saying, just don't come in here anymore. Physically, you're not allowed in here anymore, any of them. That's what he's talking about. So he was trespassed from Land O'Lakes for this. This is what we're here for, the Land O'Lakes location. In the meantime, what they're doing is just sending a letter saying, don't come to any location now, without actually going through the whole process for each location, like they had to before. So, all right.
I wasn't aware of that.
Yeah, they did. They sent the same thing to me last year.
So, just give me one more second. I just want to go through this one last thing here. Yeah, I just wanted to reiterate, opposing counsel already addressed staff caused disruption not attributed to me, so they said we were getting the weeds on that, but there was one thing I wanted to bring up again. Okay, yeah, it's the very first main argument that I made, or second main argument I made earlier, was that the county bears the burden. A phone in hand does not equal recording, and then, you know, even if there's a video that turns up later on the internet, which it did, you know, that does not retroactively cure missing predicates at issuance. The question is whether at the moment of the warning, the ordinance's requirements are satisfied. So just want to bring that up again, that they were not met in that regard. So, that's all I have.
Alright. So what I'm gonna do is, like I did before, on all of these, and Mr. Phillips knows this, but so you know, I take in all the evidence that was admitted, take down my notes, and then, the video will issue a written order in 10 business days of the day. So that'll conclude this hearing. Do we have any further hearings today?
No, sir.
Thank you.
Thank you.
Thanks.
I'll hold them like they were diamond, bro. All right, everybody, that concludes the hearing. Special motions for special motion to suppress constitutional arguments. I don't know. This is the DMCA lawyer, everybody. This is all the freedom haters' worst enemy.
That's true.
Do you hate freedom? Stay away from this guy.
Or copyright infringement.
Do you hate copyright infringement? It's not Saul Goodman. All right, there you go. There's the hearing. Everyone have a good day.